Welcome to the Garrulous Gavel. I'm John Tico, and my guest in this episode is Mark Zaid. Mark has a fascinating practice focused on national security and government secrecy, and we'll be talking to Mark about why the government keeps secrets and some of the legal tools that can be used to pry open that secrecy. Along the way, you'll hear from Mark about some of the high-profile cases and clients that he's handled over the years, including a Freedom of Information Act case that Mark brought seeking revelation of the oldest classified documents being held by the U.S. government. You'll hear from Mark about what those documents turned out to be. And you'll also hear about Mark's representation of clients that have included Alexander Vindman, former Secretary of Defense Mark Esper, and actor John Cryder of 2.5 Men fame. And then we'll get garrulous with Mark about his love for old comic books and hear his views on a hot topic in the comic collecting world. If you press the wrinkles out of an old comic book, do you have to disclose that when you sell it? Stay tuned to find out the answer. And if you enjoy this show, please rate us, leave a review, subscribe. It only takes 15 seconds for you to do. And hey, it makes us feel good about ourselves. And why wouldn't you want to do that? Thanks so much for listening. Welcome to the Garrulous Gavel. I am John Tico. My guest this morning is Mark Zaid. Good morning, Mark.
Good morning, Jonathan.
Our topic today is going to be government secrecy and various things that lawyers do to challenge secrecy in various contexts. We live in a democracy where government openness and transparency is really important so that the citizenry can understand what its government is doing and decide who to vote for and against. But there are situations where the government wants to keep things secret. We can think of obvious ones like military plans, cutting edge weaponry, ongoing criminal investigations, but often the government tries to keep the cloak of secrecy over a much broader array of information and data. And lawyers like Mark help their clients try to pierce through that secrecy in various ways. And Mark is one of the really nation's experts in this area of law. So we're really honored to have Mark on the podcast. We're going to start by learning a little bit about Mark's background and how he came to this practice. And then we'll turn to that little substantive area of government secrecy, and Mark will teach us what he knows about that. And then at the end, as we often do, we will try to learn something about our guest that has nothing to do with law. And it turns out that Mark is a comic book aficionado. And this is actually overlapped with his legal career in various ways, as I think we'll probably cover at some point. But we're going to talk to Mark a little bit about comic books at the end. So this should be a really fun conversation. So I'm going to start where I normally do. Now, normally at the beginning, I ask my guest, hey, tell us, where you grew up. But I'm going to actually do it slightly differently this time. Mark, tell us, what is a garbage plate?
What is a garbage plate? Garbage plate is the most delicious food ever created 100 years ago, actually, a little bit over, in Rochester, New York, where I went for my undergraduate years. And a place called Nick Tahoe's was created in 1918. And there was a lot of railway workers and other blue-collar workers who didn't have a lot of money. So this plate was created that they could afford and had so much food on it that they could survive for the day just on this one meal. And then the folklore story is that sometime around the 1960s or 70s, a college student in the town came in one night drunk, which was quite frequent back in the day, and said, I want that plate with the garbage on it. And it became the garbage plate. Now, it's really just like hot dogs or cheeseburgers, hamburgers. It could be scrambled eggs. It could be fish. It could be a veggie burger in the modern world. But my garbage plate is 2 cheeseburgers, mac salad, home fries, onions, and this mysterious meat sauce that we don't know the recipe to because it is secret, which fits into the theme for today. And it is a beloved food item that has its own Wikipedia page, and people should Google it and visit Nick Tahoe's in Rochester, New York for a garbage plate.
Well, that's great. It seems to me from what I know that every upstate New York town or small city has something like that. There's some like strange food item. One of my kids went to school at SUNY Binghamton, and there's some like weird sandwich that you can only get from like 2 places in Binghamton, and that's like the food lore up there. So it doesn't surprise me that Rochester has something like that.
No, and the garbage plate has been copied around the country because people from Rochester or who went to school like I did, they moved somewhere else and they remember it fondly, so they create it. And I mean, the reason why, and I get this all the time because people associate me with the garbage plate because I'm a huge advocate for this business and have fundraised for them during COVID time. And,
right.
and I've been helping fundraise to purchase garbage plates for Rochester's emergency workers, firemen, policemen, medical workers over the last couple of years because I love it. It's such a piece of history in Rochester.
That's great. So are you an upstate New Yorker by birth, or did you just move there for college?
Just for college. I'm a downstater. I am from Long Island, about 30 miles from Manhattan in the shadows of New York City, and then went to college in Rochester, right up by Canada, and then law school in Albany. So I've made my rounds throughout New York State, very different parts of New York State, and then settled in the Washington, D.C. area 30 years ago.
Oh, okay, that's interesting. Well, I'm also a fellow Long Islander, so there you go. Two New Yorkers, two ex-New Yorkers who ended up in the D.C. area talking to each other 30 years later.
You talk to anybody in the D.C. area, and it is rare that New York is not somehow a part of their life. I question, when it's not, I question who that person is. Absolutely.
So you went to law school at Albany Law School, which is also in upstate New York, a really old, storied law school. And you graduated from there back in the early 90s, probably around the same time I graduated law school. Mm-hmm. And what did you do right after law school?
So I knew I didn't want to be in a big firm. I had a negative experience with a medium-sized firm for Albany, just in how they conducted work and their law clerks and young lawyers. And I was always looking to work for the government at some level, whether it was local, I worked for the mayor of Albany, or state, I worked for the lieutenant governor of New York, or federal, which was ultimately probably going to be my design, which actually never happened, but morphed into what my law practice is now. And so at first, I actually just stayed up in Albany for, you take the bar, you graduate in May, you take the bar in July, and then you sit there waiting for the results, which you get in November in New York, and then you sit there for more months waiting to be sworn in. So there's nothing you can do unless you're in a law firm. I was not in a law firm. So I worked for the mayor of Albany, running his sister city program, or the city's sister city program, writing speeches. So it was a good foreign policy job in upstate New York, which, I created it. It didn't exist. I told the mayor, hey, you need to hire me, and he did. And then that job ended, and by the time I got sworn in March, after almost a year from graduation, I looked around for jobs. I lost out on a New York State Senate job to someone's cousin, and I said, well, I'll forget this. I've already lost out to nepotism, so I'm coming down to D.C., and I just moved to the D.C. area without a job, figuring I'd find something down here.
And what did you find?
I've always been a good networker, and I started to just call folks who I had met while I was in Albany. I used to come down to D.C. for conferences. My focus at the time was, frankly, dealing with war crimes and terrorism. I was working on trying to amend the Foreign Sovereign Immunities Act to allow victims of terrorism to sue terrorist states for their atrocities in a civil case. And I reached out to a lawyer named Alan Gerson, who sadly passed away just a couple of years ago. And I had brought Alan up to Albany for a conference on terrorism. And as a result, he was retained by a victim, a family member of the Pan Am Flight 103 bombing, which was in December of 1988. That bombing was something very personally tied to me. The University of Rochester, we lost 2 students on board. I was actually studying in England in the spring semester of 1988. They were on the program in the fall semester of 1988. You may know some folks or connections too, because most of the victims were from the New York City area because the plane was coming into JFK. So there was someone from my hometown who I went to synagogue with, and ultimately became friends with lots of people who he worked with because he was a Justice Department lawyer hunting Nazis, actually, in the Office of Special Investigations. And so it was something incredibly personal to me, and Alan asked, hey, I was just hired by this individual. We're going to sue Libya. Do you want in? And I leaped at it. So I helped draft most of the first civil lawsuit against the government of Libya in 1993. Ultimately, we represented several dozen family members, and after 10 years of effort, we settled with Libya in 2003 for $2.7 billion. Every victim got $10 million, or every family member got $10 million per victim, which was paid out over a number of years. And 33 years later, we just memorialized the anniversary at Arlington National Cemetery. I'm still working on the case in representing the victims and trying to help them achieve justice, because we don't really believe we've done so yet.
Yeah, I mean that is an amazing way to start your legal career. Like
that was the start.
To have that be the first big case you take. What, you were like a year or two out of law school at that point?
Graduated in May of 92, moved here, admitted to the bar in March of 93, moved here in July of 93, filed the first lawsuit in Scotland, technically, in September, the first U.S. lawsuit in December of 93, and on my way.
And so have you just sort of basically had your own practice right from the get-go? Like, you were never working inside of somebody else's firm, is that right?
Pretty much, other than there were times where I was of counsel inside someone's firm, but I was always I wouldn't even say 10, I guess I must have always been a 1099, tax reporter. So there was always my firm that existed, my firm that did the taxes. So if I had a relationship with another firm, it would just be like a pass-through that was then paid to me. I mean, nowadays, my firm, I have relationships with other firms where we're of counsel to one another because we're in a niche specialty, and we just bring in the other experts as needed. Literally the turnoff I had in law school with a firm, I'm like, I never want to be anything other than the boss so that I can make the decisions. And, 30 years later, it's working out well so far.
Yeah, well, I think that's great, and it was certainly brave of you to do that back at the beginning. I've talked to a number of people on the podcast who started or run their own firms. Those folks often tend to be interesting folks who are doing interesting things. But I think you're the first person I talked to who basically did that like day one right out of law school. Hey, I think it's a lesson out there for folks who are thinking of going into the law that, one of the nice things about this profession is it's one of the few professions that are left where you can get some training and hang a shingle and start a business.
I think it's even, I have lectured to law students or encouraged law students over the years, especially when I was younger in the 90s, and I would work with a lot of law professors, and I would handle, back then, really high-profile cases. And to see a young lawyer, and I mean, I like to think I look younger than what my age is. Some people are telling me that it's not necessarily what I think it is in my mind, but I can tell you in the 90s, I looked a lot younger than what my age was. So it looked like I'm this little kid doing all these big cases. So to come in and talk to law students who, are barely 2 or 3 years younger than me and say, hey, look what you can do. I think actually it's easier to do it now because of the internet. We didn't have any of that, obviously, when we started practicing. So I think it's a lot easier to be able to create a law practice on your own in today's world than it was back then. But look, there are certain skill sets you need. But I will say there was nothing that I did that I don't think someone else can do. I mean, I'm not some prodigy, like some incredible talent. It was a lot of things that also just fell into place, thankfully. And it is something I would definitely encourage, because I think the key thing, I think we can say this about any profession, if you're not doing something you love, you have a horrible existence. And while I love money, money's awesome. I got cool collectibles and stuff behind me and elsewhere. It's not worth it if you're not enjoying what you're doing, because as a lawyer, especially, we put in so much time every day. And I don't work a 9 to 5. I'm on call literally 24/7. I work on the weekends. I work in the evenings and 2, 3 in the morning, which is my preference, quite frankly. But I'm not on anyone's schedule. I'm on everybody's schedule.
Yeah. So how did you deal with just sort of the practicalities of learning how to litigate? I mean, one of the nice things about going into a firm or going into a large government office is that there are certain kind of nuts and bolts parts of being a litigator in particular that you don't necessarily learn that in law school. Just how do you draft this kind of document request? What's the right way to handle yourself the first time you go in front of a new judge? Just kind of these practical things. So were you able to find, mentors or people that you could reach out to, and kind of how did you sort of deal with that part of your growth as a lawyer, just hanging a shingle right out of law school?
No, exactly. Those are all really true and valid points. And I didn't hesitate to ask questions. And I learned early on how different what the books tell you, the way the process works, and then learning the reality of how the process works. And in New York State, we have something called McKinney's, which is the law, the books, the name of the books for the statutes in New York. And at the back of the McKinney's volume would be sample motions. And I remember I had a criminal case in my early day, literally a month into my law practice, and I had to file a motion to get someone out of jail. They had been detained too long without charges. So I follow the motion, what it says in the back, and I fill it all out and everything. And I'm an assigned public defender. You just get hired, the county or the city hires you for just those cases. And I went up to the full-time public defenders, someone who's been experienced, and I show them, can you look at my motion? I'm about to go, Judge. What do I do? Is this right? They look at it. They're like, what is that? I've never seen one of those. We don't file that. Just tell the judge that your client's still in jail and hasn't been charged, and they'll do something about it. It's like, oh, okay. And I got to tell you, even 30 years later in law practice, because of what I do in the national security arena, I am still finding that many of my cases all the time are novel, have no precedent whatsoever, and we are making it up as we go along, trying to use our best judgment in a reasonable way. And sometimes we've created new law. Other times we've been knocked on our duff by the court saying, what do you think you're doing? It happens. Some of it, law is very much at times experimentation as much as it is setting and maintaining precedent. But it was just making sure to ask questions along the way and talk to lawyers who are more experienced. And I always found, and I do this back to other younger lawyers now because it was done with me, I always found that the more senior lawyers were very open to that, and maybe even, honored that you were asking them, can you please help guide me a little bit along the way?
Yeah, absolutely. Absolutely. Well, that's what I always tell new lawyers who come to our firm. Just ask questions. It's better to ask the question at the beginning than to have to sort it out at the end when you've made the mistake. Well, so you have your own law firm now, and do you have other lawyers working for you now within the firm?
I have one full-time junior law partner who has worked for me for 15 plus years. I hired him when he was in law school and groomed him. What we do is not rocket science, but it's very much something you need to learn how to do. And it is a great deal of understanding the tone and demeanor of how you handle these cases more so than what you might argue. And that is something that is taught and learned rather than something that you can just kind of, do your research, draft something up, and think you're going to succeed. It doesn't work that way in the national security world.
Right.
And I have other lawyers who are of counsel, other firms, like I said, that are of counsel. And I bring in other lawyers. Sometimes could be another individual lawyer, could be a large firm, top-notch firm that I'll work with on cases, whatever might make sense. Practice of law is also very much one about friendship and the relationships that you've carved out along the way with people around the country and around the world. I mean, I have cases involving lawyers in other countries too.
And so I think of you as sort of a national security lawyer, but how would you describe sort of the scope of your practice?
I say, because everyone always wants to put some label on you, national security attorney is generally what I use. A transparency lawyer, an employment lawyer. I learned like 20 years ago, I got denied for a malpractice policy. And I'm like, why? Why would you deny me? I have done nothing. I don't have any complaints against me or anything. And I learned from the underwriter, it was because I kept explaining that I'm a national security lawyer on all my paperwork, and they didn't know what that was. Mm-hmm. So I had to switch it to, I'm just, and I mean, this is true. I'm an employment lawyer. I'm a federal employment lawyer. It's a lot more bland. And I mean, and to show you how sensitive this is, gosh, I don't know, I forget when it was, at the end of 2019, maybe 2020, I guess it was, my insurance carrier, and this was covered in most of the major newspapers, exclusively in the New York Times, my insurance carrier, Hanover, dropped me as an insured lawyer because, and they put this in writing, because this was after I represented the intelligence community whistleblower in the first Trump impeachment process. Because I represent high-profile whistleblowers, they dropped me as a client, as an insured. I mean, it makes absolutely no sense. It's like, okay, I'm not in any greater risk. I'm at a lower risk, actually, than many of the lawyers you insure, but for somehow, because I have high-profile whistleblowers, you drop me as an insured? Oh my God, I couldn't believe it.
They didn't know how to underwrite the risk, I guess. I mean, that's how insurance companies think. Yeah, we've done those. We have to do those applications every year, and you do. We have a slightly more traditional practice, but it's that you still have to somehow squeeze it into the limited number of boxes they give you. Right?
And I worked with I tracked down the general counsel. It's all about finding who knows who, and it turns out I had mutual friends with the general counsel, and I'm like, really? Are you seriously gonna look at all the cases I represent? Members of Congress, cabinet officers, FOIA, Freedom of Information work that we'll talk about. I'm employment work. I'm in such a niche. It's so hard for anyone to be able to sue me in reality wise, or at least to be able to win, because anybody can sue, as actually I found out recently, which I'll just mention in this part of this. So they wouldn't budge. So I said, fine. So I plastered the story all over the press to say that, they turned their back on an attorney who provides pro bono representation to lawful whistleblowers. And that's who you want to turn your back on. And then ironically, a former client who politically is not, let's just say, is not in the same world as I am. The person is a Trump cultist, true born and bred. And although he used to be a very close personal friend of mine, as so many of us have experienced during the Trump years where that just friendship disappeared, he sued me for malpractice, which the case didn't even survive for a year. The judge threw it out. But Hanover, the carrier who dropped me, was stuck having to foot the bill for the lawsuit. so I paid not a dime. The insurance carrier had to pay for the entire legal representation, which I won, and the case was dismissed, and life goes on. And I'm like, okay, there you go. There's irony for you, or fate, whichever way you want to look at it.
Well, we could probably trade stories about malpractice insurers all day long, but I'm not so sure that that's podcast material. So let's kind of turn to the topic we really want to talk about today. And this is the area that I think in many ways is kind of central to your practice. And that is this world of government secrecy. So let me start by just asking a very kind of high level question. What are the things that the government is permitted to keep secret? And how do we know that? Like where in the law is the guidance, if you will, for what the government can keep secret and what they can't keep secret?
Sure. So look, our government has kept secrets since before we were even a country. President Washington had an ad hoc intelligence operations where there were secrets. Obviously many of them would relate to military operations and diplomatic discussions with other countries where there are spies and intelligence being gathered. In modern time, our hierarchy for national security and classification, declassification is primarily through executive order. And especially since I think the Eisenhower administration is where our executive orders on these topics basically started. Right now, the governing executive order is one President Obama issued in 2009. President Trump did not issue any executive orders on classification, declassification. I'm told President Biden, there's one in the works. But really, since President Clinton issued his in 1995, 1996, very little has changed in the executive order. And it sets forth the categories as to what can be classified. Every so often, the legislative branch tries to instill a legislative component to it, which the executive branch generally pushes back on. But there are some examples, like the Jfk Records Collection Act, which defines how records relating to the Kennedy assassination, which was recently in the news because President Biden authorized the release of additional almost 20,000 pages. I work on those efforts all the time. So they statutorialize some of the declassification. They did that for some of the Nazi records also. But predominantly, national security is in the purview of the executive branch and the President of the United States. And decisions as to who has access to classified information, such as I have a top secret sensitive compartmented information clearance, TSSCI eligibility at the moment, which varies from case to case, to who decides what information is classified or declassified goes from the president down to their designees in each of the agencies.
And does the executive order give sort of substantive guidance on the types of information that should be classified versus what should not be? Or is it more just procedural?
It is, think about like kind of a 30,000 foot view. So foreign relations of the United States, information pertaining to the foreign relations of the United States can be classified. That's almost anything. I mean, you could really fit in the categories. I want to say there's like 7 categories of information that can be deemed properly classified. Then there are classification guides that many of the agencies have created, some of which are classified in themselves because we're not able to understand if the agencies think if we understand how they classify or why they classify information, that would give us a better opportunity to fight the classification determinations so that we could have the information declassified. And we've tried over years to get access to these classification guides. I think I once sued the SEC, Securities and Exchange Commission, for their FOIA manual, actually, and they fought us on it tooth and nail.
Are there limits to what the president could decide should be classified? I mean, what if, for example, the president just says, any reference to well, I'll just give a crazy hypothetical. Any reference to my children should be classified and never shown to anybody. I mean, can the president do that, or is there some constitutional limit or legislative limit on the president's ability to keep something secret?
So it's a complicated question. Ostensibly, there's no limit other than the checks and balances that exist in our democratic system. There are lots of examples of ridiculous information that's been classified. The Eisenhower administration used to classify its menus for the meals, which I can understand, like if it was an advanced menu, because you want to make sure the president doesn't have his food poisoned. But, certainly after the fact, I'm not quite sure if the menu deserves classification. The categories, like I said, are so broad, but there is a hierarchy that does exist that allows the federal judges to challenge it. And actually, back in the 1970s, in the Ford administration took the position that federal judges could not even overrule classification decisions of the executive branch. And the Supreme Court rejected that, and then the legislature actually was aghast by it, and so amended the FOIA to the Freedom of Information Act to specifically give federal judges the authority to challenge the president's and the executive branch's invocation of classification. So the executive order sets forth these guidelines. They can be really broad, but the judiciary does have the ability to challenge. Although we are descendants of the Kingdom of Great Britain and its Official Secrets Act, we have never gone that far. We have actually always had the opposite, where the Freedom of Information Act is a disclosure act, not a classification act. It is actually says it very clearly that the premise is to require disclosure unless one or more of the exemptions, the 9 exemptions, apply. Okay, so maybe this is a good time to just turn to that. I think the two kind of big areas that I think we could touch on today that I think are central to your practice that relate to kind of ways to challenge secrecy and to get disclosure from the government. One is Freedom of Information Act, and then the other interesting area I think is what is it called? Pre-clearance review. Is that this is sort of when a government insider wants to disclose something? Yeah, pre-publication review. And there's also a third one, and actually pre-publication review, ironically, is not a declassification process. It is this unusual feature of just making sure that the information is not classified. In some ways, it's very inconsistent. It doesn't make sense. You submit a manuscript for review to see if there's anything classified. If it's classified, the government will tell you to excise that information. But if they allow you to go forward with publishing it, that doesn't mean it's been declassified. Mm-hmm. And there actually have been FOIA litigation making that argument. Hey, I'm trying to get access to these secret documents. I have in my hand a book written by the former CIA director talking about those documents. And the federal judge is like, well, that doesn't mean it's declassified. Maybe they were making it up. Maybe they deliberately published classified information for a operational reason. So it's very different. So from a declassification standpoint, you have FOIA, and then you have a mandatory declassification review request, an MDR, which is set forth in the executive order, which is a fantastic process, but it has its differences. FOIA, by statute, you submit a request. The agency has 20 working days to respond, which most agencies will never meet. It's just physically, frankly, practically, realistically impossible. They don't have the resources. But you can go into court on the 21st working day, and you can compel disclosure unless, like I said, an agency can meet one or more of the 9 exemptions. An MDR request, you have to have a specific document in question. So FOIA request could be, I want all documents pertaining to the death of Princess Diana, which was a case that I handled, and we can talk about if you want, versus an MDR request. I want Inspector General Report number XY1234. And you can't sue on an MDR request, but it goes through a much longer process through the agencies that you've submitted it to. But the beauty of it is if that agency denies the request, it can then go up to an appellate body that is comprised of officials from multiple agencies called the ISCAP, Interagency Security Classification Appeals Panel, that is operated through the Information Security and Oversight Office, which is part of the National Archives right now. Nobody's ever heard of any of these entities, but they're great people, great bodies. Whenever anyone hears about the classification czar, that is the head of ISU, which has been in existence since the 1970s. But this ISCAP panel, comprised of representatives from the DOD, the State Department, the CIA, and I forget who, Interior Department, wherever, like a whole, 10 or so people, whatever the number is nowadays. And they sit in judgment over this request and their sister agency's determination that the information is classified. And historically, they have about a 75% reversal rate, meaning they reject the sister agency's classification determination and order the information to be released. It's a slow process, but it's actually a very substantively meaningful process.
Okay, that's really interesting, and I've never heard of that myself. I think a lot of people understand FOIA, or at least have heard of FOIA. Maybe don't understand it in its details, but that is a new thing for me. So, Mark, I know you've done a lot of really interesting FOIA cases over the years. Is there one that you could sort of describe to us as sort of a good model for how those types of cases work and how fights over the FOIA exemptions play out?
Yeah, so I've had a lot of really cool cases. I try to make my cases fun when it really comes down to it, because that's what life is all about at times. So back in 1998, I created an organization called the James Madison Project. Still exists, and it is an organization, nonpartisan, that promotes the reduction of secrecy and educates folks on transparency policies, classification, declassification. And I asked the National Archives at the time, what are your oldest top 10? Like, David Letterman's still on air, he's still popular. What's your top 10 list of oldest classified documents? And 6 of them were about invisible ink, World War I invisible ink, the Germans' use of invisible ink during the war, the Great War, and like the documents about the formulas. One of them was in French. It was information that had come from our allies and came to the United States, and they were classified. And so I thought, well, this would be a great first case for the James Madison Project to challenge and promote the reduction of secrecy. So we sue the National Archives, and what I have done in my law practice, because predominantly I'm up against the U.S. government or governments, government of Libya, government of Equatorial Guinea, bunch of over the years that I sue. Getting press in these cases can be incredibly helpful, and weaving a story to help promote what we're trying to do can make a difference. So this was a very fun case that folks wanted to cover. Why is the U.S. government classifying nearly a century-old invisible ink formulas? Now, it turns out, so here it is, I sue the National Archives because they're in possession of the documents, but it's not their documents. Actually, the documents there was a Commerce Department document because they were trying to deal with invisible ink that was being used in the mail. The U.S. Postal Inspection, the post office was looking at use of invisible ink because people were trying to scam postal inspectors. There was other documents. Some were military documents. But it turned out that it was the Central Intelligence Agency, my old friends at the CIA, that had classified the documents. Even though the CIA didn't come into existence until 1947, in the early 1970s, somehow the CIA told everybody in the government, because I saw the memo, we take jurisdiction over anything pertaining to invisible ink, and it's considered classified. So that was by itself pretty interesting to find out. And now, again, remember, we're not dealing with American secret ink formulas. We're dealing with German World War I secret ink formulas that we, our allies, actually had already defeated, broken the formulas, and then sent them to us as part of the process. So really couldn't understand what was going on with this. And when I first filed I remember my first court appearance before Thomas Penfield Jackson, a senior sitting district judge at the time. Again, this is almost 25 years ago. And I remember him saying, he's like sitting back in his chair laughing. He's like, didn't I get this formula in my breakfast cereal in the 1950s? And, you know, I thought the Washington Post has already written about this story. I mean, he turned to me, he's like, I bet you the media would be interested in this case. And I'm like, oh, yeah, I think so, Judge. Yes. Meanwhile, he still ultimately ruled against me in the case.
Let me stop you right there. So maybe you could just say a tiny bit. We don't have to get like super technical, but like, what was the legal issue? Like when you say he ruled against you, what was the government arguing? Were they saying that that these documents fell within one of the FOIA exemptions, and what was that about?
The CIA claimed that they could use the formulas in the war against terror. And I put in the briefing examples of all these formulas. I got access to books that were in the FBI's library that I got through interlibrary loan that had formulas from invisible ink, multiple different formulas, dozens of them. I found articles written by the same people who wrote the classified documents, because understand, in FOIA cases, the government has to do what's called a Vaughan Index. It's the name of a law professor at AU, American University Law School, who did a case back in the 70s. And a Vaughan Index is basically, there's no set form, but basically the government has to give you some sort of list. Okay, who authored the document? Who was the document sent to? What's the date of the document? How many pages is the document? And a summary as best as possible that can be released that would enable the requester and the lawyers to be able to challenge what the exemptions are. Now, that's obviously more difficult in classified cases than it is for an unclassified deliberative process case, where they could certainly summarize a document without revealing the actual document. So I had all these details about these documents. And, you know, there was like one document from 1932 by either Postal Inspection or Commerce. So I sent in a separate FOIA to that agency, and I said, can you give me any documents that you have on this? And they sent me documents pretty quickly that were written by the same guy. It was very clearly an unclassified article that they had, that the same guy who wrote the so-called classified document wrote. And I have no doubt, I don't remember, I've never compared the two, but I mean, now someone can, because I'll get to why. And it was very clear they overlapped. So I'm like, Judge, how can this be classified? It's like classifying the periodic table. It's like, this is ridiculous. But no, he's like, hey, the agency has explained to me in a classified declaration why the information needs to still be protected 90 years later. I didn't understand the decision, quite frankly. I still don't understand the decision. And I stuck with the case. And we later on filed an MDR, mandatory declassification review request, for the information. And rather than deal with the fact that we were probably going to win that, the CIA released the documents in or around, I don't know, about a decade ago, I think. So somehow the passage of about 15 years meant the terrorists no longer could make use of World War I invisible ink formulas.
So how long did the MDR process take?
I think it was pending probably for like over a year, and we got some press stories. A colleague of mine, I think I was one of the requesters, and they represented me. or the James Madison Project, I suppose. And it was already pending for like a year or so, and it was, the writing was on the wall that the information was probably going to be released. And there was a lot of PR about it. People were still interested because now these documents were almost 120 years old, or so 100 years old, over 110 years old.
Yeah.
And it's like, this just makes no sense. But it's one of those things where at times this is a perfect example of overclassification, oversensitivity, that I think works to the disadvantage of the agencies. There's an old saying, I want to say Potter Stewart said it, Justice Stewart, when everything is secret, nothing is secret. I think it came out of the Pentagon Papers case in 1971, as I recall. I'm paraphrasing it probably by a couple of words. But it was basically sort of like the boy who cried wolf. You know, if you say it too many times, you're just diminishing the validity and credibility of what you're really trying to protect. And right. I will tell you, because I do have access to classified information, authorized access, which I'm one of the few private lawyers in the world that I work in who typically does have classified access, because I represent people who work at the CIA and inside the intel community, and their very affiliation with that agency is classified. And I will tell you, there is absolutely classified information that needs to be protected and can never be revealed. I have absolutely come across information that it would be harmful not only to the United States, but to individuals if it were released. Sure. But I've also seen some of the stupidest things classified over the years. I think my first FOIA lawsuit against the CIA involving a high-ranking senior official about the Kennedy assassination. And this was back in the 1990s. And after 9 years, we got declassified from the CIA the fact that Allen Dulles was the third director of the CIA. It's like, I'm pretty sure that was public when Allen Dulles was appointed the third director of the CIA back in the late 50s.
Yeah, so let me ask you about that. I mean, you obviously have sort of a unique window into this classification world, and as you said, there is a lot of overclassification. So, you know, from your perspective, why does the overclassification happen? Is it people just are being super cautious? Is it people are trying to hide things that are embarrassing but not really of national concern? Is it just bureaucratic malaise? I mean, some combination of those. Like, from your perspective, why does that? Why are there too many secrets?
There are a number of reasons. I'll rattle off a few. For one, nobody ever gets in trouble or fired for classifying information. You better bet people get in trouble and are fired if they, unfortunately, release information that someone higher ranking than them later decides, why did you do that? In fact, we recently learned of a FOIA policy at an agency. I don't think it was an intel agency, just any agency, but they were giving awards to the FOIA officer who could redact the most number of pages in a month. Really? I mean, again, the statute's a disclosure statute. It is not a prohibitive disclosure statute. So it seems completely antithetical to what the premise of what actually the statute is intended to do. There is also a level of egotistical importance. If my information that I'm working on is classified, that must mean I'm doing really important work. So the higher it's classified, the less people I tell, the more important I think of myself. And that happens all the time. Ironically, if you work at the CIA and you send an internal message to a friend, hey, I'll meet you at Starbucks for coffee at 2, it's automatically classified just on the nature of their message system. Clearly, that's not classified. And I've been to the Starbucks and Dunkin' Donuts that they have in the CIA many times, and there's nothing classified about it. It's the same Starbucks and Dunkin' Donuts that exists anywhere else. No difference in their formulas for their coffee or donuts. But that has always been a problem. There is definitely, and actually in the FOIA statute, you are not allowed to classify information solely for the purposes of covering up embarrassment or criminal activity. It doesn't mean that embarrassment or criminal activity cannot be withheld, but you can't for the pure purpose of classifying it to cover that up.
But have you seen instances where that does occur? Because I think that's often people's sort of suspicions. Like if you were a suspicious person outside the government, you might think, oh, the government is just keeping stuff secret because they don't want us to know. It's embarrassing to whoever, is in charge that day. And it's all a big conspiracy to keep the citizenry out of in the dark.
Yeah, it happens. Those are really hard arguments to be made. And we have tried over the years to broaden it to say that if the information reveals illegal conduct, that you can't classify it at all. But the courts have narrowly interpreted it to be that the reason why someone classified it was purely to protect the illegal conduct. And that's almost impossible to prove because we very rarely get discovery in FOIA cases. If we do, it usually surrounds the adequacy of the search. Like what search terms did you use? What database did you check? Did you go over and look in that file cabinet? You don't usually get anywhere as to the mindset of why did you classify that or what is your basis for withholding it beyond what you get in the sworn declarations that are filed. But I mean, there's a slew of history that shows information to be classified. I gave another anecdotal story. This is what I typically see, and this is I have as recently as yesterday, in fact, in a particular case. But I can tell you back, I remember a case I litigated in the 90s regarding Gulf War syndrome, this mysterious ailment that was plaguing our service members in the first Gulf War who were coming down with all sorts of sicknesses and nobody could figure out why. And I represented CIA whistleblowers who we sued for documents pertaining to Gulf War syndrome. And I think it was Judge Jackson again, the same one who handled the Invisible Ink case. I had him before. And when I first started the case, there were something like 300 classified documents. I think the Defense Intelligence Agency mostly controlled them. We filed a request, 300 classified documents. Within a few months, they're like, I'm going to make up numbers because I don't remember the exact. It's like, okay, we looked at it, and even though we said those were classified, we're going to give you 100 of them right now. Here you go. Okay, fine. We litigate a little bit more. We file some briefs. As the briefs are being written, the government goes, we've reassessed it again. We're going to give you another 100 more of the documents. It's like, oh, okay, I didn't even make any arguments yet this time. It's like, okay, then I make a whole bunch of arguments. Like, all right, we read what you wrote. And it's like, okay, we're going to give you another 90 of the documents. Now there's like 10 documents that are left out of 300 that were classified. They said, nope, not giving them to you. They're classified, sensitive, harmful to the United States. And I remember some of the documents were hand-drawn maps that the defense attaché had drawn in Iraq while like driving down the roads, these dirt roads, was literally drawing maps of this is what happens here and there's a fork over here. And I'm like, I have no idea how to argue that these are not classified. I don't understand why they're classified. I don't know why they shouldn't be classified. I don't even know what they show. It just makes no sense, right? This is after the war. I can understand during the war why they would be classified, but we already won. There's nothing left. There's no more fighting going on. Anybody could go there and travel and do business and everything. And I remember getting up to the judge going, Judge Jackson, I try to be reasonable and rational. I don't have an argument. I don't know what to tell you. I have no idea why these records are classified. This is what I'm going to ask of you. There's a small number of pages. Will you look at them in camera, right? For those of the non-lawyers, look at them yourself. Bring them into your chambers. You look at them, and because they're classified, he has to look at them, not his law clerk, because the law clerk probably doesn't have a security clearance. Look at them, and I will defer to whatever you say. I mean, I have to defer whatever they say anyway. Obviously, they're the judge, but I was basically saying, whatever you say, I accept. I'm not going to appeal it because I don't know. I don't know what to even tell you. He's like, and I remember then sitting down, and I remember putting my hand on my head, kind of leaning down, going, okay, I don't know what else to say. And I remember listening to him. He's like, I've been doing this a long time. And whenever I look at these documents in camera, and I'm like, okay, here it comes. Everything is classified and stuff. He's like, I usually don't understand why the government has classified them. And I'm like, what? I'll look at them in camera. Yes, government, send them to me. And then I'll go. They showed up in the mail a week later. The government released them all. So I'm like, okay, what a great system.
Yeah, so I mean, you had so they went from 300 to 0,
pretty much,
without the judge actually ruling.
Right.
So yeah, I mean, so that's interesting. So the hand drawn maps. I mean, that kind of raises the question in my mind of, is there must be a lot of documents where the reason for the classification or the reason for the secrecy is legitimate at when it happens. But then there's passage of time, right? And something, obviously, I mean, your Invisible Ink example is a great one. It's just sort of like, okay, in the middle of the war, maybe this is something that for whatever reason you want to keep secret, or you want it to be secret that our government knows this, or whatever the justification is. But then you've won the war is over. It's now no longer actionable intelligence. It's just history, right? And so, is there some system within the government to deal with that? In other words, like, does the military have some system where they periodically look at things that were classified and try to declassify them? Or is there just this huge trove of classified information waiting for Mark Zaid to file the next lawsuit, and it's then that somebody goes back and looks at it and makes the determination?
Right. The executive order actually sets a 25-year frame, and at times up to 50 years, for information that is supposed to go through periodic review to determine if it's still classified. I mean, it is an enormous task because there is so much information. Again, with the advent of the internet and the public use of the internet, beginning really in the 90s, and email, the number of documents has exponentially gone up because of how much work is done electronically. But there's more and more AI systems being developed to be able to review these documents to determine whether or not they still have to be classified. And after a period of time, the records are supposed to be automatically declassified unless the agency certifies that there is a legitimate reason as to why that information needs to be continued to be classified. So time, yes, as a first rule, will impact the nature of the classification. It is an argument always to be made. And then you can come up with examples. So here I've been working a great deal about the Kennedy assassination. I helped craft the law and the policies surrounding the release of the Jfk records in the 1990s. I helped craft the definition of assassination records for the Assassination Records Review Board, which the Congress created in 1992 and went out of business in 1998, but the law still exists. And like I said, we just had a release in December of almost 20,000 pages. There's still quite a number of pages that are supposed to be released in the next year by the administration. And everyone looks and says, come on, the Kennedy assassination happened 58 years ago. Why should information still be classified? Well, I'll give you an example of actually why some information should be classified. Small number. Lee Harvey Oswald went to Mexico City in September of 1963 and met with Cuban and Soviet officials in their embassies in Mexico. And we monitored his visits. We monitored them electronically with surveillance and photography, and we also had sources, it appears to be, inside the embassies who reported to us. Traitors, Soviet and Cuban traitors to their countries who could be executed if ever found out, who were feeding the CIA information about who showed up at their embassies. Now, 58 years ago sounds like a lot. I mean, it's older than us, right? I wasn't born yet. It sounds like a long time, 6 decades ago. But, these folks working in the embassies were in their 20s. They're our parents' age. You know, my dad's still alive at 84 years old. So was someone who worked in the Cuban embassy in 1963. And I'm pretty confident that if the Cuban government in 2022 found out that someone had been a traitor in 1963, they would not hesitate to arrest that person and possibly execute them. So not revealing the identity of an asset or information that could be used to identify a human asset, even 58 years later, because of Cuba and or Russia today, could make a difference. But, you know, when you look past that, efforts to kill Castro or to subvert Khrushchev 60 years ago, does that information still need to be classified? Yeah, different story.
Right. Yeah, that's really interesting. From what I've read in the paper, you're currently involved in or have recently been involved in a fairly high-profile pre-clearance review matter involving former Defense Secretary Esper. Is that right?
Yes.
Is that still ongoing?
Still ongoing. So
what can you tell us about it that's
sure.
That wouldn't get you in any trouble?
So, former Defense Secretary Esper, one of Trump's Secretary of Defenses, served for 2 years or so, has written a memoir that is scheduled to come out in May of 2022, and there were about 50 or so pages that were deemed to be classified by the Defense Department, a number of its components, and the National Security Council, so the White House. And
so maybe just stop right there and just explain really briefly what is the process that led to that.
So anyone who has had access to SCI, sensitive compartmented information, a top secret TS-SCI clearance is how most people hear it. The contract that they sign, the non-disclosure agreement, has a mandatory pre-publication review obligation that any writings, frankly, any speeches too. I mean, look, there's a ton of inconsistencies. And when I lecture on this topic or I teach at Johns Hopkins in their master's program on national security. And I always say, when it comes to this for pre-pub review, the policy, the practice, and the law can be completely different. So the law says you have to submit everything to ensure there's nothing classified in it. Now, anyone who has access to what we call collateral classified information at the secret or top secret level, they can't reveal classified information to unauthorized third parties, but they don't have a mandatory in perpetuity pre-publication review requirement. I always still suggest that they follow it, they submit it, because you'd much rather be told up front if it's classified, change it, rather than get prosecuted later on or anything of that sort. So, obviously, as a Secretary of Defense, Secretary Esper, any secretary would have access to SCI and has a mandatory review requirement. Submits the memoir or book, whatever, or article or op-ed, whatever, or speech, whatever it might be, for review. Hopefully, an agency will get back within a reasonable period of time. Doesn't always happen that way. What is reasonable will vary. Depends on what's going on in the world. Depends on how long the manuscript might be. Depends on, obviously, the contents. And whatever agency you submit it to will vet it and farm out any of the contents to other agencies if equities are identified. So in Secretary Esper's case, it was primarily DOD, but it was also the National Security Council that had equities in the manuscript. So about 50 or so pages were deemed to be classified, and some very important stories, of which the color, as the secretary would describe, the color was stripped out of the contents of the book, and it would impact the readability of the book. So the government takes the position that no lawyer is allowed to have access to the manuscript because we would be an unauthorized third party, even though I happen to have the appropriate clearance level. Doesn't matter. I litigated this case 20 years ago. I won at the district court. I then lost at the Court of Appeals that the district judges are supposed to make the determination first without the lawyer until they decide that the lawyer plays an essential role. We obviously play an important role with respect to being able to litigate the case and things like that. but I have to do it without having access to the manuscript. So I'm just told, what the client can tell me about generically what's been redacted. I see what the government has written back in an unclassified format. I'll say the government reveals classified information through unsecure systems all the time, which is just kind of a joke in a negative way. And then I'm like, hey, I will sue, because the law is very clear that anyone or everyone has a First Amendment right to publish unclassified information. The government has to defend that the information has been properly classified. So it can't be because there's a policy difference. It can't be because there's embarrassment. It can't be because they just don't want it to be published. It has to be classified properly. So I filed the lawsuit back in, end of November, I think, Thanksgiving weekend or so. And so now that has been, 6 weeks, give or take. And I would say of the 50 pages that was classified, last I was told, I want to say like 48 of them are now not classified.
Yeah, so it's just another example, like in the FOIA cases, where just having the lawyer go to court and kind of force the government to sort of get serious.
Yeah.
Right. I mean, we see this
all about oversight.
Yeah. I mean, we see the same pattern in civil litigation, where we sue a big company and we ask for some category of documents in the case. And the first move is always to raise a bunch of objections and say, we're not going to give them to you. Right. But then when you file the motion to compel in court, all of a sudden, oh, well, we've reconsidered. We'll give you some of the documents. So it's that same sort of like better safe than sorry mentality that you were talking about before, which is, hey, if nobody ever calls me out on this, the better thing to do is to keep it secret.
No, that's exactly right. Every time I tell clients that, I would say 90% of the time, I'll be able to extract more information from the U.S. government when I can get judicial oversight over the process and get them to evaluate. And oftentimes what turns out is that the information is not classified. It's just the agencies prefer that it not be released. And I also tell clients, like, look, and I tell the government, if you can persuade my client not to publish it or to change it, I don't have any issue with that. My issue is they have a First Amendment right to publish unclassified information. And if you're going to tell me it's classified, you need to defend it. And there's a process that we will do that. I'm now representing Chelsea Manning, which many people would think would not fit within my type of client because I represent whistleblowers who do not release classified information. But Chelsea is going through the pre-publication review process and following it, and I applaud that. And I will help anyone do that to make sure that the information is properly reviewed and national security interests are protected, but also that it's not excessively classified that can't be defended by the U.S. government.
Well, I've got to ask you about one other matter that you've been involved with, because it was such a high-profile matter, and I'm just curious to know what you can tell us about your experience as a lawyer in the middle of it. And that's during the first impeachment proceeding that was brought against President Trump, probably the star witness, maybe, or at least the witness that got the most public attention, was Alexander Vindman, who was sort of within the national security apparatus at the White House. And my understanding is that you came to represent him and maybe some of the other players in that drama. So maybe you could tell us a little bit about how that came to be and what that experience was like.
Yeah, so I ended up representing Alex after the impeachment process had ended. Alex is a twin. His brother Yevgeny was also in the White House. They were both active duty Army. Yevgeny, as a JAG, still is a judge advocate general for the non-lawyers, so a lawyer. And I represented Alex for the pre-publication review of his memoir that came out a few months ago. And I still represent Yevgeny in a whistleblower complaint for retaliation of his participation in the whistleblowing activities that led to the first impeachment. But while the impeachment process was going on, I was representing with a colleague of mine, Andrew Buckeye, who works for me, with me, and I represent, because he's a whistleblower at the CIA. We represented the IC, intelligence community whistleblower, whose complaint led to the impeachment proceedings where everybody got to meet Alex Vindman when he testified in uniform, and the others, the ambassadors, etc. And that was during the period of September 2019 to about February, March of 2020. That person's identity has never been publicly revealed. The complaint was initially classified. We had access to some of the classified information. We worked it through the system lawfully so that everything done was done by the book, which is why, as far as I know, the individual is still an employee within the intelligence community, has never, to my knowledge, suffered retaliation because we did it the right way. And our job during this case was to, one, protect the identity of the client, which we did, protect the client from retaliation, which we did, and make sure the information that the client wanted to convey to the oversight authorities, in that case Congress, was so conveyed, which we did. Our objective was never impeachment. That was a political decision by the branch of Congress, the legislative branch of Congress, to pursue. And while we worked within that system, it was mostly to protect, if not exclusively, to protect our client. And as those who remember that time period so fondly as I do, which I say sarcastically, we had to deal with people like Senator Rand Paul trying to reveal the identity of who he thought was the client. And in fact, the only time Chief Justice Roberts refused to ask a question given to him by a senator was Senator Rand Paul's questions twice, I believe, where he contained or included a name that he believed to be the whistleblower. And Justice Roberts, even though there was no legal obligation, to his credit, from a moral standpoint and what the law should be, refused to read the question. So it was an incredibly tense, stressful, difficult time, but very proud and successful time. We got lots of death threats during it. There was a guy prosecuted for threatening my life who served over a year in jail as a result.
Yeah, that is really amazing. I mean, and that's just sort of a great example of the role that lawyers sometimes play, of just having to sort of stand between their clients and, hostile forces that can come from all directions. In that case, obviously a U.S. senator, and just enormous public pressure, and then people doing crazy things.
Oh, yeah. The president of the United States called me a scumbag publicly. Said that I should be sued for treason, which does not exist in our law, but that's okay.
You should have it printed on a T-shirt.
Yes.
Well, I know you've been involved in a lot of other high-profile cases. You've had just a really amazing career, and the fact that you've just built that career from scratch right out of law school up until this day, it's really it's just an amazing career story that you've had.
Thank you.
And thank you for sharing this little slice of it with us and teaching us a little bit about secrecy law here. It's been just a really interesting conversation. We're going to turn to comic books, something a little more lighthearted. But I guess before I do that, why don't I say, is there any information you'd like to give out in terms of how people can find you if they need the kind of help that you and your firm give, or just places that people can follow your writings? I know you do a lot of writing and speaking. Where can people follow you and get information about you?
Yeah, sure. So website's just markzaid.com, and my email is mark@markzaid.com. I actually don't have an office phone any longer because during the Trump impeachment, we received so many harassing phone calls and threats. It was disruptive. And I have loved not having an office phone, so I never turned it back on. And it has not stopped my practice from growing, because if you're a member of the intelligence community and you can't find me, then you shouldn't be working in the intelligence community, because it's pretty easy to find me, and especially on Twitter, where I'm at Mark S. Zaid Esquire, ESQ, Mark S. Zaid ESQ, where you can follow me there, though email is always the best way to reach me.
Yeah, you're a fun Twitter follow, so I recommend that to everybody as well. Okay, fantastic. Well, tell us then a little bit about your interest in comic books. Where did that get started, and how has that intersected with your career in interesting ways?
Yeah, so it got started as it did for anyone else who was 5 or so years old, and I was a comic book reader in the early 70s. And I can remember going to the local stationery store, as we used to call them, and buying comic books off of a rack in the early 70s. And when I was in high school, I was a part-time comic book dealer. I used to sell at a show with a high school classmate of mine every month in Rockville Center, Long Island, in Nassau County. And a little bit in college, law school, dropped out of it for a good amount of years, quite frankly, about 10, 12 years. And then when we settled the Pan Am 103 case, and finally I had some money, not as much as what it sounds like with $2.7 billion, because there were lots of lawyers, lots and lots of lawyers who were in that case. But I had some disposable cash, and I went back to my love of comic books, and I started EsquireComics.com. Although the website's horribly out of date, so nobody rely on it, but it's there. And I started getting involved with mostly rare and esoteric comic books of investment quality. I love books that nobody else can find. And I particularly enjoy collecting books from the 30s and the 40s, what we call the platinum to golden age of comics. And like most things that I do, I love to combine my love for one thing with my love for another thing. So I combine comic books with law. And how I did that is I lecture on the history of comic books in general at comic conventions, but I also specifically lecture on how lawyers, and courts have impacted and influenced the comic book industry over the last 100 years. So the New York Times did a half-page story on a exhibit that I curated at Yale Law School a decade ago about comic books and the law and copyright and trademark and all sorts and characters that are, lawyers. Daredevil is a lawyer in his alter ego of Matt Murdock. She-Hulk is a lawyer as well. And of course, all the characters are put on trial at some point in time. And I'm about to do a presentation at the Spy Museum for the second time, the International Spy Museum in D.C., about comic books and espionage and how comic books have portrayed spies over the decades. But I also act as a lawyer, and I represent comic book collectors and dealers and companies that do business in comic books, especially if they're the victims of a fraud or other type of legal action. So I get to work on comic book cases as a lawyer as well. So I get to get the kind of best of both worlds. And what makes it even great is I take payment in comic books if that is what someone wants to do. That works for me. I'm all good with that.
Do you still spend a little bit of your time reading new ones, or you only like the old ones?
I don't read the new. I represent some comic book artists and writers who are working on things now, but I honestly don't read it. So when we were kids, comic books were written for us as kids. I'd style it in the mid to 80s, comic books started to shift to where they're written for adults. The average age of a comic book reader now is something like 27. When comics were really at their height in the 40s and 50s, the average age was 8 to 14 years old. So now it's graphic novels, and you're reading serious stories in just comic book format. And to be perfectly honest, the artwork lost me in the 90s. It became very cartoonish. I didn't like that style. So I stopped, I'd say, in the early 80s. I mean, I go to all the Marvel movies and I follow all of that, of course, and I know people connected to the films. And of course, obviously, every time a new film comes out, it just raises the value of the comic books that have those characters in it. So I relish off of that because they're pulling characters from mostly back in the 1960s that we all grew up with. And, you know, in the Avengers and all the individual characters and the X-Men, things like that. But I became a very outspoken advocate for transparency of all things in the comic book community, just like I do in my national security environment. There is a great deal of overlap, and it's been a really fun adventure, literally, to kind of deal with both fields and combine them.
What is the transparency issue in the comic book world?
Oh, we had to deal with issues involving restoration of comic books and things that would be done to comics that would not then be revealed by the seller. And what constitutes restoration in the comic book field, which is different from other hobbies, in fact. So we dealt specifically with something called pressing, which is what you would think it would be, you know, literally pressing a comic book to kind of remove wrinkles and creases within the book and waves that within the paper. And there we had a very, very active debate 15 years ago on, does that constitute restoration? I believe it does. I lost, quite frankly, the war. I won a bunch of battles. I lost the war about it. And, you know, such is life.
Why would, I mean, okay, this is getting really esoteric.
This is in the weeds of comic books.
I know every hobby, like I have hobbies too, and you get any group of hobbyists together, whatever the hobby is, right? They will immediately dive into some like super minutia that only they care about. So what's the big deal about flattening out the pages of a comic book? Why would you care about that?
Well, because the definition of restoration was to restore a comic book back to its original form. So if there was a piece out of the book, you restored the piece. If there was a tear in the page, you repaired the tear and you revealed it. And restoration was looked down upon, unfortunately. I don't think it should be, but it would reduce the value of the book if the book was restored. Still does. It's not as bad. It's not as stigmatized. But to me, pressing was a minimalist form of restoration. I don't really have a problem with it by its nature. And I don't care if anybody, I buy restored books. I'm all for it. Sometimes that's the only option you have, of book that's 90 years old, 80 years old. It's the only time, you know, or maybe it's the only one you can afford because the unrestored book would be so valuable. But it was all about transparency. I wanted to know, did you do anything to this book? Maybe it would impact its value, maybe it would not. Problem was, scientifically, it was very difficult to determine if a book had been pressed, and people were unwilling to reveal it. I had a book, just as one quick minutia example, a book that had restoration done to it. The restoration was removed, and then it was sold as unrestored. Well, it was an unrestored book, but to those of us who are purists, we wanted to know, you know, had it been restored previously? Because some people might not have wanted to own it. I didn't have a problem with it. I still bought it, but I wasn't told that. And I never dealt with that comic book dealer again because they withheld the information from me deliberately because they thought it would minimize the value of the book. And, you know, like in every hobby, you know, there are those who care more about the dollar value of it rather than the history. I care about the history first, the dollar value second. Both are important, but there was very much a transparent. I mean, we wrote articles about it. We had debates at San Diego Comic-Con about this issue. But I acknowledged that I eventually lost. I represent the company that grades comic books now, and they have a pressing service. So, you know, clearly I've moved on.
Huh. Okay, that's fascinating. Well, I was more of a baseball card kid growing up than a comic book kid, and I have boxes and boxes of these old baseball cards from back then. But I think
me too.
I think I've got a few. I think I've got a few old comic books. I'll have to dig them out and show them to you someday.
Please,
and you can tell me if I can use one of them to finance my daughter's college education or something like that.
Absolutely can. I'd be happy to help you. And I can get a discount on grading services for you.
Awesome. I mean, the one other thing I noticed, I think in something I had read online about you, was that one of your more famous clients was somebody you met through this sort of comic book world. Is that right? John Cryder?
So I met John Cryder of, Pretty in Pink, Ducky, and 2.5 Men, Alan Harper. I watched that show probably every day. Law and Order and 2.5 Men, I pretty much watch every day, at 1 a.m.
Yeah, well, that was before. Well, I don't know when you were watching it, but sort of before it became entirely obvious that Charlie Sheen was crazy.
Yeah,
right? It was like,
yeah, you can watch the transformation for sure as he starts to go downhill. But John and I met on Twitter a few years ago. But it turns out, one, he's from Long Island also, so there's always a Long Island bond. But he is a comic book fan, particularly a fan of the art of Jack Kirby, who was the co-creator of Captain America, among so many other amazing characters. Joe Simon and Jack Kirby created Captain America in 1941. Great artist, died in the 1994, I believe. And one of the best comic book artists around, very sought after. And John's a big collector of his artwork. And so we bonded on that. And I now he's my client because I'm representing him in a Freedom of Information Act lawsuit against the National Archives regarding FBI records about his uncle, now deceased uncle, who was a war resistor during the Vietnam War and worked with an organization that advocates against war for his entire lifetime, pretty much. And this organization was surveilled by the FBI, and their phones were bugged, and their offices were broken into in the 60s and maybe into the 70s. So we're going after files for John and his family to see about their family member and what the basic of FOIA, what the government was up to.
Yeah, that's fascinating. Good luck with that. Well, look, you've been super, super generous with your time, Mark, and this has been just a really interesting and fun conversation. Glad to have learned something about secrecy law and about the esoteric world of comic book collecting. So thank you very much for agreeing to do this. It's been a fun conversation.
No, it's been my pleasure, Jonathan. Thank you so much.
All right, take care. Thank you for listening to this episode of the Garrulous Gavel. If you enjoyed it, please subscribe wherever you listen to podcasts. You can always find us at garrulousgavel.com. If you'd like to send feedback or suggest a guest, please contact us at our email address, garrulousgavel@gmail.com, or on Twitter at garrulousgavel. Our cover art was created by artist and illustrator extraordinaire Joan Tico. Our theme music was written and performed by scientist and saxophonist extraordinaire Robert Tico, and our producer is the inimitable K.O. Myers of Particulate Media. See you next episode.